Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Good afternoon, Gord. Pleasure to see
Hi.
you as always.
Indeed. It's always a pleasure to podcast, and appreciate your efforts this week to scour the world of estate administration and come up with interesting topics. You're very good at that. And today, you've got an interesting one for us. So why don't you introduce it?
Yes, well, thank you. I go to all lengths, and that includes watching TV. So the idea of this podcast really came from a show on Netflix. For our listeners, it's called Fisk, and it talks about a case where the deceased had written in her will that she wanted half of her estate to go to her daughter and the other half to go to her son on the condition that he got a vasectomy. And the reason being is that he had fathered 5 children with 5 different women, and so the mother wanted to make sure that he stopped doing that and before he would get his inheritance. And it's fictition, of course, but we want to talk about it because it brought up a lot of thoughts about what conditions can you impose on someone in order for them to get their inheritance. Some are more common than others, but I think it's a relevant topic as our executors have to deal with a lot of different situations.
Right. So it starts with, if you're the executor, then you have to read the will. So of course, this is typically only in a situation where somebody passes away with a will or some type of a testamentary document. It could be a holograph will that lays out a gift that causes the executor to question. So that's sort of the message, right? If there's no will, you don't even get into this territory. It's only in a situation where is there something offensive or inappropriate about a gift in the will. And that's where you may need certainly some legal advice or potentially an application of the courts to say, well, can I actually do this? Get some guidance from the court. So in a situation where there is a will, I guess it starts with you read the will and say, well, what is it telling you to do? And in general, there's a body of law where under certain unique circumstances, the courts will intervene and make an assessment of the will that you put together, the distribution plan. We were just talking before we started recording, there was a case out of Ontario a number of years ago where somebody left the residue of the estate to an organization in the States that was promoting neo-Nazism. So very extreme views, and an application was brought to say, is that okay? Can I give the residue of the estate to that organization? So if we're laying legal principles, we start with the principle of testamentary freedom. That is, you're allowed to do what you want with your funds, with the residue of your estate, whatever's left over when you pass away. But the court makes restrictions on that and limits on that. So one of them, and we've talked about this in other podcasts, would be you have to look after those who are your dependents. You cannot leave money to exclude a minor child who's financially dependent upon you. If you have a spouse and you're in a relationship and financial dependency, you have to provide for your spouse. So it's not testamentary freedom. You can do what you want to the nth degree and without limitations. And so it falls in that category of, say, the court will step in certain circumstances, much like if you don't provide for a disabled child or you don't provide for a surviving spouse, they have standing to ask the court to intervene, right? Which is time-consuming and messy and expensive. So you want to avoid these things. So hopefully you never get into this because you've done proper planning and consulted a lawyer. In my experience, a lot of times these are cases where people are, writing the wills themselves and they're not aware of this body of law and they're not receiving the counsel to say, maybe we should put appropriate limits, or you can't go that far in terms of placing conditions on there. So we have testamentary freedom. You can do what you want with your money, but to a point. And that's sort of, we can what's the right to attach conditions on there, and how much restriction is there on testamentary freedom? To finish that example, in that other case, there was an application for advice and direction, and the court struck down that clause saying, no, it's against public policy in Canada to have this provision that promotes neo-Nazism, right? So now that's obviously a restriction on this fellow's ability to do whatever he wants. I don't think there was any any other family members. So one would say, well, why can't, you can pick whatever charity, whatever cause you believe in or that is important to you, and you could do it. But even there, be careful. There was a limit on there. It's an example of where the court will go. So a couple of points on that, and then we'll maybe jump into some examples and talk about some different limitations. There's no hard and fast rule. And what you see in this is that the law evolves. So number one is how a court interpreted something 20 years ago might be different than now, and it might be different 20 years from now, right? So there's not a rigidity to these are the rules. You'd have to look at the circumstances of each case and how the law is evolving. But it's also going to depend on the specific facts of each case, right? That there could very well be a situation that, how it's drafted or the particular situation may make a difference as to what evidence the court's going to look at and whether that tips the scale of saying this went too far. A contrary example of that, again, it was a case out of Ontario a number of years ago, Spence versus BMO Trust Company. But in that case, the person said, I have two daughters and I leave my entire estate to daughter A, but daughter B, I'm leaving nothing. Now he wrote in the will because, I don't have a relationship with her. She doesn't really, it's strained. We're not even in a father-daughter relationship. So I just deciding I'm not going to leave anything to her. As it turned out, there was evidence about a good friend of his who said, well, the reason he did that is because she was non-Caucasian, but married a Caucasian man and had a child. So a mixed race family. And that was highly offensive to the dad, the deceased person. And so then the challenge was, well, you should strike out the will. Therefore, I get half on intestacy because my dad was a racist, right? And you go, well, I mean, many of us would say, well, that doesn't seem fair. Why would, just because it's a mixed race family, is that a reason to cut somebody out? But it was interesting in that case because he didn't actually set that as the condition, or I give you the condition give the gift on the condition that you divorce your husband or something because he's not of my race. So that could fail. But in the end, the court said, well, he has testamentary freedom. And we're not going to look at this other evidence because there's nothing compelling us to say we have to go beyond the simple interpretation of the will. And he was free to give his money to whoever he wanted. And he happened to pick one daughter over the other daughter. Some of us may regard that as inappropriate reasons, but the court upheld it, right? So that's just an example of, you could say, well, neo-Nazi and a sort of a racist belief, how come it wasn't the same result? Well, you look at the way the will's drafted and how it's structured. And I think it also illustrates the point that many times you can get around this with proper planning, right? If you want to achieve a certain result, like maybe you would set up a trust for that person, as opposed to, with normal conditions that would protect against certain circumstances, like maybe the Fisk situation, to say, well, if you were trusting he was going to give it to a sixth child or a seventh child, well, you could set up a trust to say, well, it's only for his benefit for his lifetime, and then control where it goes on his death, right? But there's an example where it may be hard to say you want to control somebody's conduct and you're kind of ruling from the grave. What are some examples that you've seen in going through where you've talked about, examples of where people are ruling from the grave?
Yeah, lots of people like to rule from the grave, which may be of benefit to the beneficiaries. But one of the most common examples I've seen in the past is with regards to children that may have alcohol or drug dependency issues. And so the parent may establish a trust for that child. And in order for that child to receive monthly stipend, they have to submit a drug and alcohol test to make sure that they're free from those types of, I suppose, poisons, so to speak. But, that brings up a question. Does that go too far, Gord, in your opinion? Or is that a typical condition you can put on a gift?
I would say in that case, it would be appropriate. You could argue that's actually, there's nothing offensive or against public policy to create a situation where you're trying to protect somebody from themselves, particularly in a parent-child relationship where you go, if I just give them a bunch of money, I'm actually causing harm. And I think it's actually worse to say, well, I can't put any conditions because on your demise, you're actually harming your kid, right? So that certainly doesn't violate any principles of public policy in this sense of, well, it's so offensive, the court's compelled to intervene and say we would want to do it. I think you get into the enforceability of a clause like that. Is it specific enough? Is it too broad? And maybe the court tailors it a little bit, or how is the trustee exercising their discretion? So you'd want to make sure the trust is drafted with lots of protection for the trustee to manage and make appropriate decisions conditions, but you see that quite frequently. And you don't see cases where the court is striking that down, as much as the beneficiary may be annoyed with all that and upset that they have to engage in that. It ultimately comes down to, well, they have discretion, right? Even if they didn't do the testing, they're going, I'm just deciding not to give you the money. It may be for that reason. So that, again, a properly drafted trust would probably avoid it falling based on that one particular condition.
Another example would be for the beneficiary not to be undergoing bankruptcy proceedings because the deceased wouldn't want their inheritance just to go to satisfy a creditor of one of the beneficiaries. And I know that's still quite common, but do you have any comments in that example too?
Yeah, and I find for something like that, the issue would be the bankruptcy will be, if in terms of the person receiving the gift is the one who could go bankrupt. So if you put it in a trust, inherently, I think you've probably solved that problem, is to say, well, only give money out, it's controlled in that sense. So the inheritance will not be lost till creditors. And that's often, I've drafted lots of trusts where we go, there's marital trouble or there's creditor problems, and we put in a trust to control it for the person's benefit, because if you just give it as an outright gift, there's a high degree of this potential problem, right? That's going to occur. And I think it's appropriate to consider different trust planning to be able to do that. I think for our executors, these are some examples, where if you're reading the will, probably one of the first things would be to say, get a legal opinion about what to do with this condition. If I carry it out, am I in trouble? Or I would rather have the protection of a court order to say I'm allowed to do it versus not doing it, right? So that example in the McCorkle case where I'm given to the U.S. neo-Nazi charity, or the organization is promoting that point of view, are they going to get in trouble? So I think it was wise for them to say, I want the protection of a court order. So give me and so our listeners can know, if you're executors, if there's a tricky legal issue like that, the solution is you can go to the court for advice and direction. The courts don't like it if you're going, well, the court's not going to do your job for them. You got to make a decision. But if there's clear ambiguity or some potential legal issues, like this is violating public policy. Like if you had a will that said, well, the gift fails because, there's a condition precedent to say, well, if you don't get a vasectomy, then you don't get the gift, right? Mm-hmm. Then maybe that needs to be interpreted or challenged. Now, usually it might be from the beneficiary. So then the trustee is saying, well, I don't know what to do. I got the will that says one thing and I got a beneficiary that says another thing. So let's go to court and I'll just take the direction of the court and then I'm protected in that scenario. On the planning side of it, certainly you'd want to be careful to make sure that you don't create a will that's going to end up in front of a judge, because that's going to get a bit messy, right? And more work for the executor. So through proper planning, hopefully you can avoid crossing that line where it's not appropriate.
Well, I know with respect to marriage and divorce, I know it's quite common to have a clause that gives a gift to an in-law, so let's say a daughter-in-law or a son-in-law, on the condition they're still married to your own daughter or son upon your passing. But as we spoke prior to this call, forcing someone to get married or forcing someone to get divorced in order to get their gift is not appropriate and won't be followed through on.
Yeah, I think that's going to be suspect, right? I think a court would say, well, that's not appropriate, or you can't marry somebody of a different race, or those sorts of conditions that you don't. At some point, there's an unreasonable restraint on the person receiving the gift that it's just not fair for them to receive the gift and have that condition imposed. And that's really what the court tries to determine, looking at all the evidence to say what is appropriate in the circumstance. But if you say, for example, you get the gift, but you have to, you get a certain amount extra if you complete a university degree within 5 years. Well, that could be almost like an incentivized gift. Say you get a little more if you complete it, or a little less if you don't. Okay, that you could say, maybe somebody would say, well, I that doesn't seem fair. I wouldn't do that. But you do that. I think that falls in the camp of testamentary freedom. It's an appropriate condition with regard to that. To your point of the marriage, I very frequently will put in a clause that says this is a gift to an in-law, provided they are not living separate and apart. So you got to be careful with the condition. They could still be married. What if it takes them 5 years to divorce and be not married, but they're separated on the parent's death, right? They go, well, that person's no longer part of the family. So you got to be careful where you set the appropriate standard, which sometimes is a more difficult thing to interpret for the executor. So be careful when you draft your will, what kind of assignment you're giving to the executor to try to figure it out and be as clear as possible, and lots of discretion to the executor to make that choice. But I think those are reasonable conditions, to put in there, but something that to ensure the enforceability, you'd want to make sure that that you are drafting it as carefully as possible, given whatever the current state of the law is.
Well, and I think that's a great place to leave is, if you're an executor and you're reading these types of conditions in the will, make sure you seek legal advice, and your lawyer will be able to guide you down the next steps, whether that is to go to court for some direction or whether you're able to enforce that condition. Well, Gordon, we'll see you next time. Great chatting with you, and can't wait
Likewise.
for our next conversation. And for our listeners, please subscribe to wherever you listen to podcasts. We're also on YouTube. And if you have any questions or would like different topics in our podcast, feel free to reach out to us. We're always happy to listen to you. Thank you so much. We'll see you soon.
Take care.